Welcome to this video on common legal issues in foreign-related commercial trials. My name is Guan Baokui from AllBright Law Offices in Shanghai and Qingdao. The content of this video will cover three main aspects: special circumstances and regulations in foreign-related commercial trials, common issues in international goods, sales contract disputes, and legal issues in judicial review of arbitration. First, let's look at common issues in foreign-related commercial trials, including case jurisdiction, party litigation subject status, service of process, review of evidence from outside the jurisdiction, and the application and verification of the governing law. A case may be deemed foreign-related if parties are foreign individuals, enterprises, or organizations. Their habitual residence is outside China, the subject matter is outside China, or the legal facts occurred outside China. Disputes involving foreign-funded financial institutions are also concentrated under foreign-related commercial jurisdiction. Regarding jurisdiction, we will discuss the stipulation of arbitration clauses, the review and determination of objections to service by mail from abroad, and the handling of concurrent jurisdiction. Additionally, we'll cover the application of the, quote, forum non-convenience principle. For litigation subject status, foreign individuals and entities must submit certified documents proving identity and legal status, generally requiring notarization and consular authentication. Special rules apply to the certification and transfer of documents from Hong Kong, Macau, and Taiwan. An authorization letter does not need notarization for foreign natural persons signing before court staff with ID and entry proof. For foreign legal entities, an additional document proving the representative's authority, along with notarization and authentication, is required. A one-time power of attorney, if notarized or authenticated in the first instance, remains valid for the second instance or retrial. A clear defendant is satisfied if the plaintiff provides proof of the defendant's existence, such as valid business registration or contracts. Next, let's address issues related to service of process, focusing on the Hague Service Convention. This slide lists the participating countries as of January 2013. Countries accepting postal service under Article 10 of the Hague Convention are listed here. If a country objects to postal service, it is presumed electronic service is not allowed, and the People's Court cannot use it. Regarding electronic service, arrangements with Hong Kong, Macau, and Taiwan allow for fax and email. The time of service is the time of confirmation of receipt or the time of reply if unconfirmed within 7 days. For Hong Kong, Macau, and Taiwan, service by mail is also allowed. This slide lists the countries that have signed bilateral civil and commercial judicial assistance treaties with China as of March 2013. These treaties provide alternative methods for service of process. For foreign individuals, the People's Court deems service effective if it confirms receipt via handover to a wholly foreign-owned enterprise established in China, handover to an enterprise where the person is a legal representative, director, or manager, handover to an adult family member residing with them, or other verifiable methods. If a party without domicile in China provides an address in writing during litigation, that address can be used for service. The court may use multiple service methods simultaneously, with the service time determined by the earliest successful method, excluding public notice. Finally, let's look at the review of evidence from outside the jurisdiction. Evidence formed abroad does not require notarization if the parties have no objection. Email evidence is common and often does not require notarization if the authenticity can be confirmed through the email addresses. We now address the application and verification of the governing law. First, the governing law must be determined separately for different legal relationships, and foreign-related civil legal relationships must accurately apply the rules for the application of law. When the People's Court hears a case and needs to apply foreign law, it can be ascertained through various channels, including submission by the parties, provision by Chinese and foreign legal experts, or services provided by legal verification institutions, among others. Next, let's look at several systems and regulations, including the Supreme People's Court's Judicial Assistance Commissioner, invited mediators for cross-strait disputes under the Diversified Dispute Resolution Mechanism, the Foreign Law Verification Centers at East China University of Political Science and Law and Blue Ocean, and measures restricting exit from China. Courts may restrict individuals from exiting the country in foreign-related commercial disputes if there is an unresolved case, the individual is a party or representative, there's a risk of evading legal obligations, and their departure could hinder trial or enforcement. Our second main topic is common issues in international goods sales contracts, specifically focusing on risk prevention when signing international contracts and common issues regarding letters of credit and independent guarantees. For risk prevention in signing international goods sales contracts, attention should be paid to the contract's form, confirmation of all counterparties, and the determination and review of quality standards, including agreeing on a third-party inspection agency and the time for raising objections. When a contract has different language versions, the agreement should govern discrepancies. If undetermined, it may be considered a failure to agree on the term. For example, deposit in English law does not equate to the penalty nature of Kanshin Chinese law. Common issues for letters of credit and independent guarantees adhere to the principle of independence, meaning they are documents separate from the underlying transaction. Risk prevention includes assessing geopolitical risks and the identity of the independent guarantee issuer. Independent guarantee fraud, as defined in Article 12, includes colluding to fabricate a basic transaction, submitting forged documents, or confirming the debt is fulfilled when it is not. Courts can only order the suspension of payment under an independent guarantee if there is a high probability of fraud, the situation is urgent, and the applicant provides sufficient security to cover potential losses of the respondent. The third section covers legal issues in judicial review of arbitration, including the review of the validity of domestic arbitration agreements, procedural considerations, determination of agreement validity, and the recognition and enforcement of foreign-related arbitration awards. The review of the validity of domestic arbitration agreements involves several key laws and judicial interpretations, including the arbitration law and the Supreme People's Court's related judicial interpretations and regulations on judicial review of arbitration. Procedural considerations for determining the validity of arbitration agreements focus on the time and institution of the determination. These include when objections are raised before or during the first hearing of the arbitration tribunal, or through a jurisdiction objection in court litigation. In procedural matters, the subject making the request must be a party to the arbitration agreement. Furthermore, there must be an actual dispute for a confirmation application regarding the validity of the arbitration agreement to be considered. Determining the validity of the agreement involves formal requirements, meaning there must be an arbitration agreement in writing, and substantive requirements, which include clear expression of intent, defined arbitration matters, and a designated arbitration institution. Regarding the determination of agreement validity, specifically the intent to arbitrate, the burden of proof is on the party asserting lack of civil capacity, coercion, or lack of intent. Arbitral intent can be established through various means, including emails, references to other contracts containing arbitration clauses, or a contract with a legal representative's signature, even if not stamped. Next, we examine whether the matter falls within the scope of arbitrable issues. Generally, arbitration covers civil and commercial disputes, particularly contract and property disputes between equal parties. Matters involving criminal cases, administrative cases, internal agricultural collective contract disputes, and issues like bankruptcy or liquidation are generally not arbitrable. We now look at whether the arbitration institution is clearly defined. An inaccurate name is acceptable if the specific institution can still be identified. If two or more institutions are agreed upon, parties must agree on one. Otherwise, the agreement is invalid. Specifying an arbitration location is not the same as naming two institutions. If an agreement specifies an arbitration institution in a certain location, and only one exists there, that institution is deemed chosen. If multiple institutions exist, the parties must agree on one. If they cannot agree, the arbitration agreement is invalid. If only the place of arbitration is agreed upon without specifying an institution, and the parties cannot reach a supplementary agreement, the arbitration agreement is invalid, according to the Supreme People's Court's response. If parties agree disputes can be resolved by arbitration or court action, the arbitration agreement is generally invalid, unless one party applies for arbitration and the other does not object within the stipulated time. Also, merely agreeing to arbitration rules without specifying an institution renders the agreement invalid, unless a supplementary agreement is reached or the rules clearly designate an institution. We now address special circumstances where parties change after the arbitration agreement is signed. This includes the effectiveness of the arbitration agreement following the merger or division of civil entities, the death of a party, the transfer of claims or debts, and during bankruptcy or liquidation procedures. The arbitration clause maintains independence. The contract's change, termination, dissolution, or invalidity does not affect the arbitration agreement's validity. Agreements allowing appeals against the arbitration award or time limits for initiating arbitration also do not affect the arbitration clause's effectiveness. Our final segment covers the recognition and enforcement of foreign-related arbitration awards. This involves key articles from the arbitration law, the civil procedure law, the New York Convention, and related judicial interpretations and regulations. According to the civil procedure law, a court may refuse to enforce a foreign-related arbitration award if the respondent proves no arbitration clause, lack of proper notice, improper composition of the tribunal, or the award exceeding the scope of the agreement. Refusal also occurs if enforcement violates public interest. Judicial review of foreign-related arbitration awards adheres strictly to formal review and does not involve substantive review of the award. Therefore, courts generally do not support claims related to the merits of the arbitration, such as issues of forged or concealed evidence. We now review the governing law for determining the validity of foreign-related arbitration agreements. The relevant legal bases are listed on this slide, including articles from judicial interpretations concerning arbitration and foreign-related civil relations. First, a foreign-related civil legal relationship must be established. The validity of a foreign-related arbitration agreement is primarily governed by the law chosen by the parties. If no choice is made, the law of the place of the arbitration institution applies. The choice of governing law for the contract does not automatically apply to the arbitration agreement. This chart provides a comparison of the validity requirements for domestic and foreign-related arbitration agreements, highlighting key differences and similarities between the two types of agreements. For other procedural issues in foreign-related review, matters like insufficient notice or procedural flaws in the arbitration tribunal are reviewed under the procedural law of the arbitration or the arbitration place. Issues of non-arbitrability or public policy are reviewed based on the law of the court's jurisdiction.